SJC-12395 in the matter of a juvenile.
Mr. Dougherty, good morning.
Good morning, Your Honors. May it please the Court. Thomas Dougherty on behalf of the juvenile. Today seems to be statutory interpretation day. Your Honor, I'm here with my issues being the interpretation of certain language of 11972A as it relates to my particular defendant and the court's decision to transfer a hearing and basically violating, in my opinion, notice requirements as afforded under the Due Process Clause and Article 12.
If you would step back and tell me how this played out at the hearing. So I know that they alleged rape.
Yes, they alleged forcible rape.
And you had an evidentiary hearing?
We had a transfer hearing under 11972A. Prior to the hearing, the charges are docketed in the juvenile court as precisely that, only that. Now, the statute, the magic language I'm looking at, Your Honors, is the offense charged. And I think the statute is pretty clear and unambiguous that the judge, the hearing judge, gets to find probable cause on the offense charged. I think that language is pretty clear. Looking at the legislative history of this particular statute, there are some minor changes, but I would argue that those changes are not substantive as to address anything other than the offense charge, meaning it's an evolution of the statute just for purposes of modern English, if you will.
So this is an all-or-nothing game for you?
I believe it is, Your Honor. I believe the statute's clear that it's an all-or-nothing game for the judge as well.
Could the prosecution bring new charges after could they recharge based on the lesser included, or would they be prevented for some reason by double jeopardy or something?
Well, I don't think double jeopardy applies. I did mention that in my petition, but I didn't brief double jeopardy. Your Honor may be correct, but I would argue that in this particular case, that would be an improper thing to do.
There could be, I'm sorry, Chief, there could be a defense attorney that argues, you know, they didn't charge or they didn't prove rape by force, but they may have proven statutory rape, so therefore,
well,
right? You could argue that in the next transfer hearing.
Well, if the court were to, in the totality of all the circumstances in this particular case, deem that it would be in the interest of justice that the Commonwealth be required, in which I would submit that if the court were going to lean that way, they would be required to recharge in the juvenile court and resubmit to the juvenile court and have what I would call a full transfer hearing as opposed to the partial hearing, if you will, that did in fact take place in this particular case, Judge.
As a practical matter, as an experienced lawyer, you know darn well that the charges entail lesser included offenses, right? Of
course, Your Honor. However, the juvenile court is not a court of final jurisdiction, and as the Williams case that the court cited in its decision to transfer, I would submit does not apply in this case. Now, it certainly is sound legal reasoning as far as a judge of final jurisdiction determining and, in fact, deciding whether or not to find guilty on a lesser included offense. But I would submit that 119 restricts the hearing judge from making a determination as to guilt or innocence or finding on a lesser included or not. It's a probable cause hearing strictly defined by the statute. If the legislature wanted the court to entertain lesser included offenses, as my brief indicates, Your Honor, I think they would have amended that language in the most recent amendment to say that. They didn't, Judge. It says the offense charged. It doesn't even say the offense is charged. It says the offense charged. And if you look back in the legislative history of of the statute, I couldn't find a single case where a lesser included offense was transferred without the predicate offense being transferred along with it, except for one case, Commonwealth versus Juvenile 1990, where the juvenile judge, prior to the hearing, indicated, and I believe it's cited in Porges, told the lawyers before the hearing, this is what we're going to have I'm finding that we're going to have a hearing on the lesser included offenses here, ladies and gentlemen. So there was ample notice to the defense lawyer at that time that was the charges that were going to be heard, Judge. Why that's important in my particular case is because, as you know, the transfer hearing is a two-part process. There's probable cause, and then there's the issues that this court has most recently, I want to say over the last 3 or 4 years anyways, has meticulously and painstakingly gotten into the ramifications of the immature juvenile mind as it relates and inures to the judicial system, and as far as rehabilitation and things of that nature. And that was stomped all over in this case, Judge.
Yeah, well, that's what I want to get back to the question that I asked, which you didn't fully answer. I know, precisely because a transfer hearing has these two elements, probable cause and, if probable cause, discharge. Tell me how this played out. It was a presentation with regard to probable cause. And did the judge make a finding on the bench, or did the judge do it later as to whether or not it was a forcible rape or a statutory rape?
Yes, Your Honor. Well, it's kind of strange how this went down, Your Honor. The hearing took place, the Commonwealth proceeded, and as the court stated in pages 3 and 4 of the transcript, okay, we're proceeding on 3 counts of forcible rape. The Commonwealth presented evidence on that. I crossed on that issue, having prepared for only those charges because the notice...
I get that, we get that.
At the end of that, Your Honor, most respectfully, the Commonwealth made a motion to amend the 3rd count to statutory rape, arguing some kind of, we find, and I objected. I said, Your Honor, most respectfully, I don't see that charge, and I wasn't noticed. I believe I said that on the record, and then I asked to write a memorandum, and the court had indicated that you can file whatever you want, but I've already made my decision now. But she did not put her decision on the record, if you will, during the transcript. Approximately a week later, she made written findings utilizing the Williams case as reasoning as to finding, arguing it's part and parcel of the transfer process, et cetera, and I should have known, or I was put on notice because of the Williams case.
Okay, but what you're telling me, I guess, is that the judge did not, at the end of the evidentiary hearing, make a finding that this is statutory rape and then say, now that you know that, I'm now going to hold a discharge hearing as to whether or not the matter should be discharged or it should proceed to the Superior Court.
That's correct, Your Honor. There was no opportunity to be heard on the issue of transfer because the court made its finding and transferred it, the lesser included, which was never noticed in the dockets or prior to the hearing, unlike in Commonwealth versus a juvenile 1990, where the judge noticed the parties before the hearing took place that this is what we're having, these charges are the charges we're having a transfer on.
So along those lines, and I know that this doesn't answer your statutory interpretation question, but if we were to decide that offense charged included within it the lesser included offense in a different context, in Commonwealth versus Williams, which is a different context, what if both you and the CPCS Youth Advocacy briefs make, I think, very important points, as you just did now, that you're preparing for rape of a child with force, and now you've got a situation where it's statutory rape, and you go into the second phase, and you might very well not be prepared for that. That's completely understandable. What if there could be a continuance as to that second phase if there is a determination of the lesser included offense. And I'm not asking you to put aside your statutory interpretation issue because we'd never get to that point if we agreed with you.
Well, I would argue that that's perhaps what the judge should have done, was say, well, I'm going to entertain, even though it's not noticed, I'm going to entertain this lesser included situation, if you will, Your Honor. And Mr. Dougherty, we're going to continue this, and you can call in whoever you want and perhaps experts. And in fact, I had consulted with some experts, one particular expert, Ms. Canonis, who's an expert in this particular area of recidivism and with juveniles, et cetera, in preparation about a year before. But then as I looked at the evidence that slowly trickled in from the Commonwealth, like pulling teeth in discovery motions, and I was able to determine that, well, gee, in order to survive this particular charge, all I have to do as a defense lawyer is disprove a necessary element, which was obvious from the records that I had before me. So it wasn't necessary then. There's two parts you can do. Either it didn't happen defense, or they can't prove a necessary element. And being as the only charges before the court, in compliance, I would argue, with 11972A, was this force charge, and they could never prove that case, in my humble opinion. It was not necessary to prepare for the stage 2, if you will, the old stage 2.
Can I switch you to your second argument, which I actually found perhaps more persuasive, which is the apprehension issue? So the real harm to your client is this could have all been dealt with when he was a 16-year-old or a 15-year-old juvenile, and now he's facing these charges as an adult with serious consequences. Do you want to address the fact that apprehension doesn't mean, basically delaying 6 years, 7 years? I mean, everyone.
10 years, Judge.
Excuse me?
10 years.
Yeah, I mean, why don't you? I'm bothered by the fact that we knew all the facts here 10 years ago, and now we're transferring this to an adult court. So you want to address the apprehension point?
Yes, Your Honor. As you know, this allegedly occurred, and I say allegedly occurred, in 2007, October of 2007. There was in page, I believe it's page 231 of the record appendix, there is a reference in a DCF, it's DSS at the time, but a referral to the district attorney's office and the Middleborough Police Department of this particular alleged offense of this young person having sex with a person under 14,
Right.
Intercourse. The Commonwealth did nothing until 2009, and then in 2009 there is a SANE interview. And I have the tape, although the tape was not introduced at evidence. I found it not necessary to do that. But it was obvious from watching the SANE interview that there was no force involved in any of the alleged offenses. And still, Your Honor, nothing occurs as far as charges go. My client is all this while living in Middleborough, living in town, never moved, and in fact still lives in Massachusetts, where in 2014, he was summarily ripped out of his place of work in the evening time with a Lakeville police officer and the Bellingham police and arrested on these charges.
So are there cases guiding us on the meaning of apprehended and saying that this is outside of the meaning of, I mean, the DA knows enough, and at one point the victim's mother says she doesn't want to go forward. Second time the victim comes in for the same interview, I can't remember why they backed out, but is there a definition of the meaning apprehended to exclude this type of?
Well, I read the case, Your Honor's probably getting it. I don't remember off the top of my head, but the facts of the case were that the person had aged out of the system. It was no fault of his own that the police didn't charge him, but they were investigating still, and they found a new offense.
Which case are we talking about?
I can't, I put it in, it's in the Commonwealth's brief, Your Honor, which I frankly, most respectfully, I did read, but I didn't pay as much attention to it as I did to my own brief.
Okay.
But
the major case on point is in the Commonwealth's brief, is what you're telling us.
I believe it is, Judge. And that case stood for the proposition that even though he was apprehended after the he aged out of the system, and it was no fault of his own that he wasn't arrested and indicted, and he wasn't going anywhere. They found that it was still okay, it was still legal, they could still apprehend him, and he tried to argue that he should have been apprehended, it was no fault of his own. The court found no, that the apprehension was still appropriate as far as prosecuting him still as an adult. Now, it's a little bit different in my case, though, because in that case, there was an ongoing investigation during that time period before he aged out of the system. They found new evidence, et cetera, and then brought the charges. In my case, though, nothing has happened since 2007. No new evidence, no matter which way you cut it, no matter which way you look at it. It was transferred without the requisite notice to the defense lawyer, to the defendant, frankly, under Article 12 and the Due Process Clause, and Mass Rule of Criminal Procedure 4, which requires a party to know what the heck he's defending against before you go before a court.
But the case we're talking about is Sullivan, which is an appeals court case, right?
Yes.
Okay.
I believe you're right, Judge, yes. So, you know, I would argue that the apprehension that occurred in this place was, I know what the statute of limitations is on the case, it's 15 years, but now the kid, if he would have been apprehended and nothing changed from that date, and I got to tell you this, it's the first time I've ever seen the Commonwealth in Plymouth County not prosecute a case because a kid didn't want to go forward or a parent didn't want to go forward. They prosecute him anyways. And so, you know, I would argue, Your Honors, that in this particular case, there were so many violations of my client's due process rights, notice, opportunity to be heard, that the proper thing to do in this case would, and I would argue this, that since the only charges before the court were the predicate offenses and they got dismissed, the whole case should be dismissed. The Commonwealth obviously has a statute of limitations. They can attempt to bring it back. There's no new evidence, and that's a motion for another day, perhaps. But in this particular case, I would argue that because the predicate offenses were dismissed, so goes all of it.
All right, thank you.
Thank you.
Ms. Gauthier, good morning.
Good morning, Your Honors. Stacey Gauthier on behalf of the Plymouth County District Attorney's Office of the Commonwealth. General Law, Chapter 119, Section 72A, does allow a juvenile judge who has dismissed a charged offense for lack of probable cause to order the defendant to be tried in the adult court on a lesser included, which she does find lesser.
Could you address, I think the main argument Mr. Dougherty, in my mind, raised? Normally, you have notice of lesser included offenses. If you go to a verdict, defendant should know, defense attorneys know, you're charged with rape by force, you're also charged with statutory rape. Here, what he argues is that, well, in this unique proceeding, I prepared for I didn't do it defense because I couldn't prove force. I may have had some mitigation evidence, but I didn't put it in because I thought I was going to win. The judge collapsed the two stages. He never had the opportunity to put his mitigation evidence in, and he loses on the lesser included. How is that fair?
Well, certainly there was no guarantee going into the hearing that the judge wasn't going to find probable cause of the greater offense. She could have found, for example,
Suppose he has
force.
his mitigation expert.
So he should have had that expert ready to go on that date on the chance that she found probable cause on the greater included offense. There was no guarantee. She could have found there was constructive force. He didn't ask to present any additional evidence. He didn't ask to come back for another day so he could do any kind of mitigation, present any mitigation expert. There was no guarantee that the hearing was going to be put off to another day. So with that information that he had, that he talked about, such as a lack of a record or some kind of juvenile brain development, he should have had that information ready at the hearing to be presented at that time. It's two prongs. It doesn't necessarily mean that it's two different dates.
But maybe he read 72A when it said offense charged, that he thought it meant offense charged.
But I would suggest that's not the case, and we know that from Commonwealth versus Williams, because in Commonwealth versus Williams, they stated that The lesser included offenses are part and parcel of the transfer hearing process. I understand that in that case, the judge found probable cause on the greater charge. However, that wasn't the only factor that the Williams court looked at in determining that lesser includeds were part and parcel of the transfer hearing process. They also looked at whether the judge considered the factors of whether the defendant's amenability to rehabilitation. They looked at that as well, and I would suggest that the judge in this case did that. She took the case under advisement. She made written findings. She allowed the defendant to write a memo. Although she did say at the hearing she might not consider it, I'd note that the docket indicates that he he filed his motion about 2 weeks before she made her written decision. So I would suggest that in Williams, this court did find that lesser includeds are part and parcel of the transfer hearing process. I'd also point out, Your Honors, it's Commonwealth versus a juvenile, and this one is at 409 Mass 49. That's a 1991 case. In that case, the defendant was charged delinquent by reason of murder, and the judge found only probable cause as to manslaughter, and he kept the case in juvenile court. The court never reached the issue of whether the probable cause finding was proper because they found that any answer to that question wouldn't change the judge's decision on the fact that the juvenile should remain in juvenile court, and as far as juvenile court goes, murder and manslaughter is very similar.
But now, you had 3 charges, correct?
Correct. Yes,
and
correct.
you moved only on one to amend it to include statutory rape, correct?
That's correct, Your Honor. After a hearing, we presented our case, and the prosecutor didn't think that she had proved force with regard to that 3rd charge, so she moved only to amend that 1 charge. The judge did not make a finding on the record one way or the other whether she would allow that. I would suggest that was proper for the Commonwealth, where she didn't think she proved force, to not then try to put the case forward to the judge on force, to ask to amend it to what she felt she proved.
And when he prepared his memorandum, it was with regard to that 3rd charge as to whether it's appropriate to amend the indictment.
Yes.
It is, with regard to the 2nd stage determination of discharge, you agree it's a very different determination if we're looking at a forcible rape as opposed to a relationship which, if the law would permit it, would be viewed as consensual between a 16-year-old and a 14-year-old.
It is different. However, it's against the law to have sex with a child.
Of course it is, but you don't get to a 72A hearing unless you allege a crime.
That's correct.
But there is that 2nd stage which permits a judge, even if she finds probable cause, to determine that discharge is consistent with the protection of the public. And that seems to be a very different determination if the judge has made a finding of forcible rape as opposed to a finding of statutory rape. Do you agree that the determination legally is the same, but the issues in terms of judgment and discretion and the protection of the public are quite different?
Yes, that's correct, Your Honor. She could have discharged the case if she wanted to.
But I guess the question is, should he be given a chance after he knows that she's made a finding of statutory rape to be able then to argue to the judge, having made that finding, especially where it wasn't, well, I didn't know at the time of the hearing that we were going to get there, give me a chance to argue that you should not let this case proceed to adult court, given that we're talking about a consensual relationship between a 16 and 14-year-old, which is not consensual only because the law declares it so.
Well, my response would be that he should have been prepared to possibly get to that point, where Williams says that the lesser includeds are part and parcel of the transfer hearing process. And like I said, there's no guarantee. The statute doesn't provide for 2 separate hearings. It's 1 hearing with 2 separate prongs. So if he had evidence that would show that the case shouldn't be transferred, he should have presented that at the time.
Well, maybe the rule should be that under Williams, the lesser included offense may be part and parcel of the transfer process, but if the judge were to find a lesser included offense, the judge should provide an opportunity for the defense attorney to prepare the Part 2 mitigation.
Going forward, maybe that is something that could be, but that wasn't in effect at the time of this hearing. And again, there was no guarantee she wasn't going to find probable cause. So if he had any mitigating evidence he had, he should have been prepared on that day to go forward.
On the other hand, and I know there was no obligation by the Commonwealth, as you look at these facts, the Commonwealth could have been prepared and brought one of the indictments for statutory rape and two others for rape of a child with force.
I mean, I don't know what the prosecutor was aware of the evidence was going into the hearing.
I know, but in the light, I'm just saying it's a matter of craft and strategically, we're faulting the defendant who could have relied on what the statute said, offense charged. And I know that this is not legally dispositive, but same thing's true for the Commonwealth.
That's correct, Your Honor. But I would say that, going in, I would assume that she had felt that she could prove the 3 counts of forcible rape by constructive force as opposed to, holding her down. And when she realized the evidence came out, then she moved to amend the one that she didn't think that we could go forward on. I would just suggest that it would be illogical to compel a judge who's sitting as a fact finder and who's presumed to be instructing herself properly on the law to find that there was no probable cause because she didn't find probable cause on the specific crime charged when she did in fact find probable cause on a lesser included offense. In this case, the statutory rape, it includes 2 of the same elements as rape with force. It's not as if, we went in and charged him with forcible rape and she found probable cause on an armed robbery. It's a lesser included, it's only missing 1 offense. So even if you were to throw out the force part, as the defendant wanted to do at his hearing, there's still a crime there, and the defendant still shouldn't get a free pass. And it's also not, it wouldn't be logical for the Commonwealth then to have to, in order for a transfer hearing, to have to charge every single solitary lesser included offense to go forward in 1 hearing. That would overcharge the defendant, which I don't think is in the interest of justice.
How many times does it happen that a judge finds a lesser offense at a transfer hearing?
To be honest, Your Honor, I don't know. I had trouble finding cases. The cases that I found went back to the 90s.
So going back to Justice Gaziano's question, how much of a burden it is it if in the very unusual circumstance where that happens, you bring the parties back for a second argument as to whether it's appropriate for the case to continue in view of the finding that there's probable cause only of the lesser included and not of the charged offense?
Well, I just think it would be, repetitive. If the judge is sitting there and hears the evidence.
Not repetitive, I can understand. If you have an able advocate there, and I assume if we go back and have that hearing, he's going to argue that's not appropriate given the consensual nature of the, plus he's going to go to all the issues about how if this had been brought timely, he'd be in a very, very different posture and how unfair it is that they delayed, and we can discuss that. But regardless of whether that prevents the case, it would certainly bear on the discharge hearing, would it not?
Well, it's the same, in my view, it's the same hearing. So it would be presented at the same time.
But you're asking essentially Mr. Dougherty to say, Judge, there was nothing forcible about this. I don't even think we should consider the statutory rape, and they've only asked you to consider it as to 1, but if you were to consider it as to all 3, here's my argument, and if you were to find what I say is not even presented before you, then you should still go on and find that this matter should not go forward. That would be what you'd expect the defense counsel to do, according to your vision of what he should have done.
To be prepared for like he would be at a trial, to be prepared for the offense charge and whatever lesser included the evidence may support.
But the difference is at a trial, the mitigation issue goes to sentencing, and then he knows what the person's been found guilty of, so he's arguing only that. It's not as if he's going to the judge to say, Judge, if you were to find my client guilty of forcible rape, I think you should do X, and if you were to find my client guilty of statutory rape, I think you should do Y. He knows what the judge has found, before he's making that argument, so he's in a different posture.
Well, then I would say that maybe going forward maybe there should be a split in the hearings. However, at this point, there wasn't. It's just the second prong, and I would suggest he could have still done that. I mean, it's clear, he's saying that he wanted to get rid of the force. So it's clear, even if he gets rid of the force, there's still a crime there. So why not go in and present evidence as to why it shouldn't be transferred on a statutory rape?
Can I, before we lose you, could you address the apprehended point? I mean, I read Sullivan both times. I don't really follow it very well, but here we have what's left in this case is consensual sex between two juveniles, but now we've got this brought in the adult context with major stakes. There's something odd about this. Why is this, and all this was before the juvenile court. All this information was readily known to the Commonwealth in 2007. So why does this meet the definition of not apprehended?
Well, I would suggest this case is analogous to Sullivan.
There's not a lot of analysis in Sullivan, just so you know, but go ahead. Yeah.
Right. So in this case, according to the testimony and the evidence, the complaining witness did not want to go forward at the time of the incidents back in 2007. She testified that she liked the defendant. She was a 13-year-old girl, and she liked this 16-year-old boy, and she thought that they would be together someday, and she didn't want to go forward. And contrary to my brother's assertion otherwise, we don't force child victims of sexual assault to go forward if they don't want to.
It sounds like you did all the right things in 2007, and then 2009 we have a sane interview, so something else kicks in, right?
Yes,
It's when we try to convert this into adult proceedings.
And she didn't want, well, I'm sorry.
10 years later.
I apologize, Your Honor. The testimony at the transfer hearing was that when she was 15, she didn't want to go forward with the case. So that was in 2009. That was when she did the same.
2007, her mother doesn't want to go forward.
Correct.
2009, she doesn't want to go forward.
She doesn't want to go forward because she likes the boy. And then in 2014, when she's 20, she presents herself to the Middleborough Police Department and says, I want to go forward on this, this old criminal matter.
And that's
so
the
we went
meaning
forward
of
on
not
the,
apprehended until...
And this is very similar to what happened in Sullivan, Your Honor, if I may. I know I'm running out of time. But in that case, it was the defendant was 16 and the victim was 14 years old. There was a rape that occurred in 2003. The police investigated the crime when the defendant was 17, and then the victim was saned, and there was a follow-up investigation that was completed also when the defendant was 17. And then in 2006, after the defendant turned 18, the victim went forward to the police, or she went to the police department and told them that she wanted to go forward on the complaint. Then the police took out a complaint, and when the defendant was 19, the complaint issued out of the juvenile court. And the defendant argued in this case that he wasn't responsible for the delay, so he didn't evade the police or anything. So therefore, he was not apprehended after his 18th birthday because he was available to the court prior to his 18th birthday. And the court held that that was not the case. The court did say that it might be different if the delay was due to bad faith on the part of the Commonwealth. And I would certainly suggest that based on what we've heard, it was no bad faith on our part that we didn't prosecute the case back in 2007 or 2009.
All right, thank you.
Thank you, Your Honor.
Let's take our morning break.
All rise.